I'm joined by Harry Litman of the Talking Feds YouTube channel and the Talking Feds podcast. We've previously talked about that Supreme Court decision in the Fisher case regarding the obstruction of official proceedings, where the Supreme Court said that you really can't bring an obstruction of official proceeding under 1512 C2 DOJ unless it has this nexus with the destruction of documents. It's a big deal because Donald Trump was charged with 1512 C2 in two of the counts, obstruction of official proceeding. So the question was, is the DOJ going to continue to pursue 1512 C2 charges against Donald Trump? There still would be two other charges against Donald Trump. And we had hints. They teased us a little bit, Harry, because in other cases involving 1512 C2, the Department of Justice in various cases either said, look, we still think that this criminal case against an insurrectionist and has that nexus to documents, and others they said it doesn't. So some cases got dismissed. Some cases got, in those cases that got dismissed, those charges got dismissed, I should say, and additional maybe charges would be brought there. And in other status conference reports, the DOJ said, no, this has that 1512 C2 nexus, so we're gonna continue to pursue it. In the superseding indictment that was brought against Donald Trump, the 1512 C2 is still there. A new grand jury was impaneled, new people were brought in. And we see right there, it was brought in the indictment, 1512 C2. So special counsel Jack Smith saying this has a nexus to documents. What do you make of it?
Yeah, so this is pretty interesting. They did dismiss Ben a ton of cases, like some 60 cases, but they kept a few. But the ones they dismissed are basically like Fisher himself, along for the ride, loving the great party with your feet up on Pelosi's desk. But where there was a theory raised in oral argument by Justice Jackson. And I agree with every word you said, with one exception, which is the nexus under the statutory language, which all of this was about, it wasn't necessarily destruction, but impair the integrity. And so the question is, can you impair the integrity of documents and the theory for January 6th? What documents are we talking about? The elector certificates, the real ones that Mike Pence opens and says, oh, yes, Arizona, check. Arkansas, check. Alabama, check. The plot to substitute for those, the phony baloney Trump certificates, is the DOJ is saying a plan to impair the integrity of those very documents. And the couple cases they've charged say just that. And that's exactly how it works with Trump. He doesn't have to have his shredder out. Rather, it's enough that what he's got this plan when he's pushing on Pence to have the phony certificates replaced, therefore to impair the integrity, what should have integrity, the real certificates, he's impairing them. So that's the theory that the DOJ is now committing itself to. It only salvages a small slice. The one case they pressed on and came back with the 1512 theory was a couple who comes in from Ohio, but they're really focused in their tweets and such on Pence and the opening of the certificates on January 6th. And of course, that is exactly Donald Trump's focus. So Justice Jackson, put this out as a theory. They've now embraced it. Down the line, will 5 members of the Supreme Court say, no, you actually have to rip it in two? Or, it sure seems to already be to fit well with the language. And remember, this is the case where Barrett departed the conservative camp, saying the language here fits even for Fisher. So now I think this theory doesn't impair the integrity of evidence. Those certificates are evidence. Seems like a pretty good argument to me, but that's the argument they'll make. That's the argument that applies to Trump. And he'll try to make a more expansive argument along the lines of, you have to trample or shred or, chew and swallow the actual documents.
There's judicial jujitsu going on here at a very delicate level behind the scenes. You mentioned Justice Ketanji Brown Jackson. She was appointed by President Biden, an incredibly accomplished jurist. In her dissent, she gave the roadmap, in other words, of how you could address conduct by January 6th insurrectionists, where they aren't physically taking paper and like shredding it and putting it through a shredder, but where they are impairing the integrity of the documents through their actions. And so in the dissent, and sometimes people go, well, why do people write dissents? Why do justices even write it? This is an example because she's giving a roadmap for, and she's a very accomplished jurist, giving this roadmap for how prosecutors can look at this issue through, through that lens, right, Harry? I mean, that was an important thing. And similarly, though, you see that jujitsu in other ways, perhaps more nefarious ways, like where Justice Clarence Thomas, for example, puts in his dissent a message to Judge Eileen Cannon about how she should be viewing the special counsel, which she kind of takes and runs with. Although I should make this one clarification, Harry, and Justice Jackson's was not in the dissent. I said that, and I was incorrect about that. She actually was. People were wondering why did she join the majority opinion.
Yeah, but this was an oral argument is where she brought up this theory and offered it up to the DOJ. But you're right, and an interesting part. This is going to play out not in the Trump case. It's going to play out in the case of this couple from Ohio. And everyone's going to understand what the stakes are. But as Fisher itself from the start had these echoes and overtones pointing toward the January 6th case and Trump, it'll be the same here. But this, I think we can you're right. It's not from a dissent, but we can well call it the Jackson theory. And just if we're talking about this, the way judges communicate with other judges on the court or even off the court, that sort of she's been quite good at sort of floating her own ideas, waiting as the junior justice, and then very gently saying, well, it seems to me that you would still have et cetera. And that kind of what seems like brainstorming in real time could in fact turn out to be the law of the land, could salvage two of the counts, as you say, against Donald Trump for a precise theory of what's it mean to impair the integrity of. Yes, they have in mind get out the shredder, but the words impair the integrity, it seems to fit pretty well to me.
And as we get closer to the election, we shouldn't forget one of the most important things about this election is there may be some additional Supreme Court vacancies. There's likely to be Supreme Court vacancies, and these Supreme Court justices who are writing now are also writing to their future selves and their future successors, and they have a long-term view of these things. And unfortunately, when it came to precedent like Roe v. Wade, you had seen right-wing justices writing to their future selves about ways to undermine it 30 years ago and 20 years ago, and no one thought that would be a possibility. But even though that's not directly on this topic of the Fisher decision and integrity of documents and special counsel Jack Smith, I just think it's helpful as a learning lesson to our viewers and listeners to say, here's what's going on behind the scenes that may not be readily apparent. I'll give you the last word.
No, so it's really true. Certain dissents, we mentioned also that she came out with public comments, which are unusual, but no more than she said in dissents. But certain dissents are meant to lay the groundwork for a future court. I clerked for Justice Marshall in every death penalty case. He always started with, I believe the death penalty is unconstitutional, even though that was a settled question of law. And likewise, Roe's a very good example. Scalia and Rehnquist, others always dissented and basically said we shouldn't have Roe v. Wade, and then went to the meat of the matter. But there are many cases, and especially sort of controversial ones, where justices try to sort of draw a line that they hope will hold in future cases. One more example in a very influential one in the abortion area was where, first in a concurrence, Justice O'Connor talked about, an undue burden, and that came to have great influence. So it's a really interesting point of how justices can talk to future courts or even future generations of courts, and their ideas can ultimately take root and be sort of out there for the next time the issue comes up, at least to be considered for, even though it didn't prevail that time around.
It's like when I made the time capsule to myself back in 1990, and I said, you are going to be a YouTuber and be with a distinguished former federal prosecutor, Harry Litman, and you're both going to spend your time talking to people on YouTube. I said,
and Mary, these things happen.
Nailed it. Everybody, make sure you go to the Talking Feds YouTube channel. Just search it, Talking Feds. It's free to subscribe to Harry's channel. They do a great job. If you want to know where I get my legal news from, it's Talking Feds. So go to the Talking Feds YouTube channel, subscribe. It's free. Thanks everybody for watching.
Real quick, Meta just changed their algorithm to suppress political content. Please follow our Instagram at Meidastouch right now as we head towards 400,000 followers so you don't miss a beat.